Let's try this again. Hey, everybody. Welcome to today's Law Self-Defense show. You probably can't see, but I actually launched a show that I was planning to air later this week. So that was a little awkward. Okay, so we're streaming okay on YouTube now and on the Law Self-Defense members dashboard, and check out, make sure Rumble's working. Let's see if I broke Twitter. Okay, Twitter's working too. Pin that up. Rumble should be working. All right. Excellent. Awesome. Everything appears to be going just fine. So welcome once again, folks, to the Law Self-Defense Show, one of our public shows. And I am, of course, attorney Andrew Branca for Law Self-Defense. Thank you very much. So as you may know, we do a couple of public shows a week. We do a couple of Law Self-Defense members only shows a week. This is one of the public ones. And so we'll be taking questions both on our Law Self-Defense member dashboard, as always. And if you are a member, I encourage you to put your questions there. You get to ask your questions and get them answered for free. For people watching on YouTube and Rumble, your questions can be answered, but they need to be a $5 minimum super chat or a $5 minimal Rumble rant. So one of the advantages of being a Law Self-Defense member is that you get to ask all your questions for free. By the way, you could become a Law Self-Defense member right now for only 99 cents. Become a trial member for only 99 cents, gives you 100% access to all our members only content at Law Self-Defense for, I think, a week or 10 days. And if you decide to stay a member, you don't have to do anything. And standard membership's less than $10 a month, about 30 cents a day. So you can try it out as a trial membership at lawselfdefense.com/trial. And in the unlikely event you decide it's not for you and you cancel, just let us know. It's support, and we'll be happy to refund 200% of your money. So you'll get a $1.98 refund should you decide to cancel. But we find that very, very few people indeed cancel. And of course, we have a sponsor for today's content, and that sponsor is none other than our very own American Law Courses. This is our series of law school level courses designed to help American citizens be the best citizens they can be by having a law school-like understanding of the laws that govern and constrain government, society, our legal privileges, and much, much more. We have a very full curriculum of courses under the umbrella of American Law Courses. These are at a fraction of the time and cost in law school without any of the political toxicity of law school. And we start with our newest class, Constitutional Law, on May 17th. So only a couple weeks away, 2.5 weeks away at this point. You can learn more about American Law Courses at AmericanLawCourses.com. And also this Thursday, we'll be doing an interview with our constitutional law professor, Linda Deno. That'll be Thursday at 7 p.m. Eastern Time live at Law Self-Defense on all our usual channels. You'll get a chance to see just how brilliant Linda is when it comes to constitutional law and a lot of other topics. She's an expert on cyber law, political science, much, much more. So we're humbled. We're humbled to have her make herself available to teach this summer semester's constitutional law class. And again, you can learn more about all our American Law Courses, and especially the May 17th launch of our constitutional law class for the summer semester, 14-week course, optional final exam at the end for certification at AmericanLawCourses.com. Let's see. Oh, and tomorrow. So for those of you who are Law Self-Defense members or thinking about it, tomorrow we are doing a members-only show on bad guy cases of self-defense. You've heard me probably talk before about the important distinctions between bad guy cases of self-defense and good guy cases of self-defense, why that distinction matters to law-abiding people like us who may find ourselves compelled to use force in defense of ourselves, our family, our property, and face criminal charges, how bad guy cases of self-defense, which are by far the norm in the criminal justice system, bias that same system against us, the good guy cases of self-defense. And we have an example of a gentleman here on the right who is claiming self-defense for having stabbed somebody 60 times and then having held on to the body in his living room for a while. So, of course, the young lady on the left is Lizzie Borden. Gave her mother 40 whacks, or father 40 whacks, I forget. Somebody got 41. So who did it better, Lizzie Borden or this lunatic on the right? We'll be talking about that case tomorrow, but it will be a members-only show. So again, if you'd like to have the opportunity to take advantage of our members-only content, I would encourage you to try out our trial membership, 99 cents, 200% money-back guarantee at lawselfdefense.com/trial. All right, so let's take a look at the case we have for today, which involves a police officer called William Darby. William Darby was called to the home of Jeffrey Parker, Darby and two other officers. And let's see, actually, a question just popped in my mind. Okay, well, I actually don't know and hasn't been widely reported, so probably not. But Officer Darby and two of his fellow officers, Officer Darby happens to be white, the two fellow officers, I believe they were both black, a male officer and a female officer, were called to the house where Jeffrey Parker was threatening to commit suicide. And he had an apparent gun to his head. Now, later it would turn out that the gun was a flare gun, which usually when you buy those, they're orange, but this one had been painted black. There's no evidence to indicate that any of the officers perceived it as anything other than a normal firearm. So the fact that it wasn't a normal firearm doesn't matter for legal purposes. It's the reasonable perception of the item that matters. It was reasonably perceived as a real gun. And by the way, a flare gun, also readily capable of causing serious bodily injury, if not death, anyway. But in any case, Jeffrey Parker was sitting on his couch with the gun to his head. He was being spoken to by the female officer standing in the doorway of the home, the front door of the home. The couch is clearly visible from the front door. I believe the black male officer was also inside the home. So this is a circumstance where Jeffrey Parker has a gun to his head. Obviously, he could in an instant point that gun at the officers and start shooting the officers. That would be a reasonable risk of those circumstances. I mean, if he's willing to kill himself, presumably he cares about himself more than others. Why wouldn't he be willing to kill others? Especially if he thought they were going to foil his plan to commit suicide. In any case, the officers are shouting at him. And meanwhile, for most of this, William Darby, Officer Darby's outside the home. He's standing just outside the doorway with a shotgun. He's not particularly happy with how the two officers inside the home are interacting with Jeffrey Parker. He feels they're taking inadequate steps to ensure their safety. They've put themselves in a position where they have no cover, no concealment. The female officer is in the fatal funnel of the doorway. She has her gun unholstered, but she's largely holding it by her side. She's not pointing it at Jeffrey Parker. So, you know, she wouldn't likely be able to respond quickly enough should he decide to shoot her. With the way she was just holding her Glock pistol at her side. At some point, Darby steps through the doorway himself past the female officer, points his shotgun at Jeffrey Darby, continues giving commands to him to drop his gun, drop his gun, drop his gun. He says then that Darby shrugged at some point, looked like he was about to move the gun away from his own head, that Parker was about to move the gun away from his own head, and Darby fired a single round from his 12-gauge shotgun into Parker with the expected mortal results. And Darby would be charged with murder for this shooting. Now, I have the body camera video of the shooting. I'm going to play that at the end of today's show. At the end, we're going to cut over to just Law Self-Defense members only, because every time I show one of these videos on YouTube, I just get demonetized, so it's pointless. So I will show the video, and that might change your perception of events. I don't know. But in any case, Darby was charged with murder in this particular case. And before he went to trial, he argued and this took place in Alabama. So that's the relevant jurisdiction. Before he went to trial, he had a self-defense immunity hearing that's held before the trial judge. And he was denied self-defense immunity. And we'll go over Alabama's self-defense immunity statute as well, so you can see how that works. So he denied self-defense immunity. You proceed to trial. He went to trial, and he was found guilty by the jury, and he was sentenced by the judge to 25 years in prison. Now, the shooting happened on April 3rd, 2018. He was found guilty on May 2021. So almost 3 years later, more than 3 years later, just over 3 years later, he was found guilty by the jury. And then months after that, in August of 2021, he was sentenced to 25 years. And then he appealed his sentence. He appealed his conviction to the appellate courts in Alabama. And earlier this year, back in March, they reversed his conviction. And we're going to read through that appellate court decision so you can see the rationale. Now, when you get your conviction reversed, of course, that's not the appellate court saying you're not guilty or you go free. It's them saying there was a legal error at your trial, and we'll detail what that legal error is. And therefore, you get a new trial without the error, with the error corrected. So Darby's been remanded for a new trial. Before this new trial, coming up later this year, he asked for another self-defense immunity hearing, which he kind of got. I guess they held it. He was again denied immunity. This is by a new trial judge. Now, often when you're convicted, your conviction's reversed, and it's remanded back for a new trial, you often go back to the same judge you had the first time for the first trial. But in this particular case, for whatever reason, maybe the first judge resigned or not resigned, retired. Who knows? There's a new trial judge. The new trial judge heard the second immunity hearing, appealed. That was rejected, basically out of hand without a written opinion by the new trial judge. So off the trial we go. So later this year, Darby will be back at trial. So that's kind of the underlying legal framework of this case. And of course, it really all pivots. The whole case pivots on the question really of imminence, imminent threat. Was Jeffrey Parker sitting on the couch with a gun to his head in the presence of three officers yelling at him to drop his gun? Did he, in that moment, present as an imminent deadly force threat to the officers? Darby says yes. In an instant, he could have turned that gun on us. And we yelled at him 6-7 times to drop the gun. He never dropped the gun. He was being completely uncooperative. As long as we were there in that room, and we were privileged to be there in that room as officers responding to this suicide call, and he refused to give up possession of the gun, he was an imminent threat to me and my partner. So defense of self, defense of others, that's what Darby says justified his firing of the shot. The two other officers involved apparently felt differently about it. They would testify at trial, as we'll see in the appellate decision, that they personally didn't feel that Parker represented an imminent threat to them, which of course is somewhat awkward for Darby's defense. That said, yeah, he's privileged to make his own determinations of risk. He's not bound by the determinations of other officers. And there was quite a bit of testimony at trial from other use of force experts, other police officers saying, in those circumstances, I certainly would have felt like I was in imminent threat of harm. So we have evidence on both sides of the question. And of course, the jury, it's within the province of the jury to give 100% credence or 0% credence to any presentation of facts to them. So a particular jury could decide 100%, we don't think there was an imminent threat. There was no imminence. There was no self-defense. Or they could say, no, 100% there was an imminent threat. So it was self-defense. By the way, when I talk about imminence, if you don't understand yet the 5 elements of self-defense, I encourage you to get our 5 elements of self-defense cheat sheet. You can get this at lawofselfdefense.com/elements. It's free. We don't charge a penny for it. Lawofselfdefense.com/elements. These are the building blocks of any claim of self-defense or defense of others. If you don't understand these, you can't possibly understand self-defense. Alternatively, you could get a more thorough explanation of those 5 elements with our book, Law of Self-Defense Principles. Check it out on Amazon, 5-star rated, but don't buy it on Amazon because they'll charge you for the book plus shipping and handling. We give you the book for free. We only ask that you cover the cost of shipping the book to you. You can get this real physical book, folks. You can get it for free at lawofselfdefense.com/free book. But one of those elements is imminence, whether or not there was an imminent threat, meaning a threat immediately about to happen. not a past threat that's over, not a future speculative threat that may never occur. The threat is either in progress or immediately about to happen. So kind of the core issue in the case here. Now, before the first trial, as I mentioned, Darby had requested a self-defense immunity hearing. Alabama is one of the states that provides for self-defense immunity. Pull that statute up here just so you can see what the legal standards are, and a little bit about the evolution of this immunity statute too, because when it was first passed into law, it shared a very common weakness with a lot of statutory self-defense immunity provisions. So let me pull up that Alabama statute. So what Alabama did was they just added the self-defense immunity provisions to their normal self-defense statute, which is just section 13A-3-23, self-defense and defense of others. Now, there was an important revision in 2016, August 1st, 2016. The current version of this law took effect, and the real change was to self-defense immunity. The rest of the statute pretty much remained the same. But let's take a look at the earlier version first. So the parts that remain the same are just not highlighted in any way. The self-defense immunity provision I've highlighted to bring it to your attention. So as usual with self-defense statutes under American law, we have conditions that have to be met before any force can be used in self-defense, even just non-deadly force. That's the first sentence here. A person is justified in using physical force upon another in order to defend himself or a third person from what they reasonably believe, that's the element of reasonableness, to be the use of imminent, it's the element of imminence, use of unlawful force by the other person, that goes to the element of innocence, and he or she may use a degree of force, that goes to the element of proportionality, that he or she reasonably believes to be necessary, that goes to the element of reasonableness. Before any degree of force can be used, even non-deadly force. And then the statute addresses the additional conditions that must be met before deadly force can be used. So what might those be? They're listed here. Let's see if there's... Before you can use deadly force, you have to meet all the conditions we just described before any force can be used, but also you have to believe that the person against whom you're using the deadly force is themselves using or about to use unlawful deadly force against you. Again, that's proportionality, deadly defensive force against a deadly force threat. Or that other person is using physical force against an occupant of a dwelling while attempting or committing a burglary of the dwelling. Or the person against whom you're using force is about attempting to commit a kidnapping, assault in the first or second degree, burglary in any degree, robbery in any degree, forcible rape, or forcible sodomy. Or, and this last one is a defense of highly defensible property provision, that they're in the process of unlawfully and forcefully, or attempting to unlawfully and forcefully enter the dwelling, residence, or occupied vehicle. If that's occurring, there's a legal presumption that they're there to inflict death or serious bodily injury on the occupants of the dwelling. So those are the additional conditions for the use of deadly force. Then they have the stand your ground provision under Alabama law. It's conditional on not being engaged in unlawful activity and being in a place you have a right to be, which are common conditions for statutory stand your ground. Stand your ground meaning you're relieved of an otherwise existing legal duty to retreat. And then they have the provisions that go to the element of innocence, how you can lose self-defense, even if you otherwise qualify under the conditions just set forward. Notwithstanding those provisions, a person is not justified in using physical force if, with intent to cause physical injury to another, you provoke the confrontation. So that's called provocation with intent. It's not just saying something mean that provokes the other person to a fight. It's provoking the other person with the intent of having an excuse to use force against them. This is the throw the first punch. I dare you, throw the first punch scenario. You lose self-defense if you do that. Or if you were the initial aggressor, or if you were engaged in combat by agreement. That's commonly called mutual combat, where two people agree to settle their differences with physical violence. And then finally, we get to the statute's self-defense immunity provision. Now, this is the version of self-defense immunity that was in effect up to August 1st, 2016. And it's very common language for self-defense immunity. A lot of states adopted self-defense immunity at similar times, and they were encouraged to do that by certain legislative advocate organizations which offer model language for these kinds of statutes. They say, hey, states, you don't even have to write anything. We'll provide you with model language to adopt. So a lot of states use the same language. Unfortunately, a lot of them adopted this language, which reads, a person who uses force, including deadly physical force, as justified and permitted under the law is immune from criminal prosecution and civil action for such a use of force, unless the force was determined to be unlawful. Well, that's great. So it's trying to say if you used force in self-defense, you should be immune from prosecution and you should be immune from civil suit, which sounds nice. The trouble is, it doesn't tell anybody how any of this is supposed to be determined. Who decides, for example, this last provision, unless the force was determined to be unlawful? Who decides if it's unlawful? The cops? The prosecution? A judge at trial? The jury? I mean, having it done at trial doesn't help you much, because the whole point of immunity is supposed to be to protect you from being dragged into trial in the first place. So presumably this would involve some kind of pre-trial hearing, but it doesn't say that. If there is a pre-trial hearing, who has the burden on this question? Does the state have to disprove your claim of self-defense at a pre-trial hearing like it does at trial? Does the defendant have to prove self-defense at the pre-trial hearing, even though you don't have to do that at trial? You don't have the burden of self-defense at trial. And whoever has to prove anything, to what threshold do they have to prove it? By a preponderance of the evidence? By clear and convincing evidence? So preponderance is 51%, clear and convincing is more than that, or beyond a reasonable doubt, the highest threshold we apply in criminal law. So it was very common for states to adopt self-defense immunity without providing any guidance on what the procedure should be, what the legal process should be. And this often led to a lot of difficulties. In Florida, for example, one of the first states to adopt self-defense immunity, they went through like 10, 12, 15 years of the trial courts making up their own standards, and then the appellate courts having to correct errors at the trial court level, and then the state Supreme Court having to reconcile different appellate court approaches to self-defense immunity, until finally the Florida legislature established in statute what the procedure was, who has the burden, by what threshold. And ultimately, that's what Alabama did too. So this rather unhelpful from a procedural perspective self-defense immunity statute, effective August 1st, 2016, was replaced by this language. You can already see just visually, it's much more extensive. So this reads now, the first paragraph is basically what existed before. A person who uses force, including deadly physical force, is justified and permitted under the law, is immune from criminal prosecution and civil action for the use of such force unless the force was determined to be lawful. That's what we already had. Wasn't that helpful? Didn't provide any guidance on procedure, but the legislature added the next several paragraphs, which do provide guidance on procedure. More than that, they mandate what the procedure, what the legal threshold should be. So prior to the commencement of a trial, so they're making it explicit, this is a pre-trial hearing process. The defendant is not required to make this immunity argument at trial to a jury. Prior to the commencement of trial, in a case in which a defense is claimed under the section, meaning self-defense, the court having jurisdiction, so that's the trial court, upon motion by the defendant, so the defendant has to request this pre-trial commencement, shall conduct a pre-trial hearing, okay, to determine whether force, including deadly force, used by the defendant was justified or whether it was unlawful. So making a finding of self-defense. That's the purpose of the pre-trial hearing. So that's going to be kind of a mini trial of the trial in a pre-trial hearing context. Now, naturally, in the pre-trial hearing, there's no jury, right? The jury's only selected for the trial. So at the trial, the judge is the finder of law, the determinator of law, but the jury is the finder of fact. The jury makes the fact finding at trial. But at a pre-trial hearing, there is no jury. So the judge is actually playing both roles. deciding the issues of law, questions of law, and making determinations of fact. He's playing the role of the jury in the pretrial hearing. During any pretrial hearing to determine immunity, the defendant must show, so this is the burden. The burden is on the defendant, not on the state. The defendant must show by a preponderance of the evidence. So that's 50% and a hair, a mere majority of the evidence. That's the threshold. The burden's on the defense. The threshold they have to prove it by is preponderance of the evidence that they are immune from criminal prosecution, meaning that their use of force was lawful self-defense. So this really just means the defense has to convince the hearing judge, who will later be the trial judge, by a majority of the evidence that their use of force fits within the legal boundaries of self-defense. If they do that, the judge will grant them immunity from criminal prosecution, and in theory from civil action, though increasingly the states are recognizing that the criminal immunity proceeding has to be separate from the civil immunity proceeding, that you don't get civil immunity just because you got criminal immunity, which kind of makes sense because at the criminal immunity hearing, whoever would be suing you is not represented there. So they don't have an opportunity to make their arguments to the judge. So increasingly you need one self-defense immunity hearing for criminal immunity and a separate one for civil immunity. And then continues, if after the pretrial hearing, the court concludes the defendant has proven by a preponderance of the evidence that force, including deadly force, was justified, the court shall enter an order finding the defendant immune from criminal prosecution and dismissing the charges. Notice it doesn't say civil liability. Again, that generally these days needs to be a separate hearing. Continuing, if the defendant does not meet his or her burden proving immunity at the pretrial hearing, he or she may continue to pursue self-defense or defense of another at trial. Once the issue of self-defense or defense of another has been raised by the defendant, the state continues to bear the burden of proving beyond a reasonable doubt all the elements of the charged conduct. This also means disproving self-defense beyond a reasonable doubt at trial. So at the hearing, the defense has to prove self-defense by a preponderance. At the trial, the state has to disprove self-defense beyond any reasonable doubt. So just because the defendant lost at the hearing level, they couldn't show 51% evidence of self-defense, doesn't mean they're going to lose a trial, because a trial, all they have to do is show the jury there's a reasonable doubt about self-defense, and the state will have failed to meet its burden to disprove self-defense beyond a reasonable doubt. So that's a much more detailed, obviously, framework for the process of determining self-defense immunity than used to exist under Alabama's self-defense immunity law, when all they had was this one little paragraph. And by the way, it's not necessarily a bad thing for the legislature to leave this kind of procedure up to the courts, because, I mean, the courts are going to have to apply the procedure. So why wouldn't you allow a reasonable court system to develop its own procedures for this? The reason that doesn't work is, unfortunately, often the courts may be hostile to the immunity provision. So they put in place processes that effectively gut the legislature's intent in providing self-defense immunity in the first place. That's what happened in Florida. The Florida courts were simply not granting immunity. So the legislature in Florida placed the burden instead of on the defendant, as Alabama does. They shifted the burden to the state. So even at the pretrial hearing level in Florida, the burden on self-defense immunity is on the state, not on the defense. And the state has to disprove self-defense by clear and convincing evidence, which is something in between preponderance and beyond a reasonable doubt. It's in that zone between those. So that's the legal process and thresholds and standards for self-defense immunity under Alabama law. And Darby tried for self-defense immunity before his first trial, was denied, was convicted, had his conviction overturned. We'll look at that decision now, that appellate court decision overturning his conviction. And now, as he's awaiting his new trial later this year, just last week, he was denied self-defense immunity for a second time by the second trial judge. So all that tells us is that both those trial judges determined, as finders of fact in those pretrial hearings, that Darby had not proven self-defense by a preponderance of the evidence, or they would have granted immunity, which they did not do. Okay, so that brings us to the recent appellate court decision handed down just about a month ago, 10 days ago. Oh no, sorry. The second denial of immunity was last week. But the appellate court decision reversing Darby's murder conviction, was handed down in March. So I'm going to pull the opinion up. Before I do, let me jump on and see if there's any questions I need to address already. Again, if you're a law self-defense member, just put your questions in the chat, in the member dashboard. And if you're on YouTube, it needs to be a $5 minimum super chat. If you're on Rumble, it needs to be a $5 minimum Rumble rant. Or you could become a law self-defense member right now, instantly, for only 99 cents, folks. And if you decide to stay a member, it's only about 30 cents a day, less than $10 a month to be a member. Get all your questions answered for free. That's at lawselfdefense.com/trial. So there are a few questions here from the Law Self-Defense members. So let's see. David asks a question about our American law courses. He says, if you start this summer with constitutional law, are the previous classes also available? So last fall, we did criminal law. This spring, we did property and evidence. Again, these are 1L level courses, law school level courses, translated into plain English for a lay audience. Those courses are available. We recorded them, of course. So you have the option to, so you can sign up for constitutional law by itself. In fact, let me pull up that webpage so you can see what it looks like. So for the spring semester, come on, websites, for our American law courses, you can sign up for constitutional law all by itself as a standalone course, or we have a number of bundles. So we have multiple courses in the curriculum. You could sign up for different bundles of courses. If you sign up for the courses that have already been done, and which we expect to repeat again live in the future, you would immediately get the recorded version of those courses that we just did, and a ticket to a seat in the next live version of that course is how that works. So that hopefully that answers that question. In terms of the elements of self-defense, are they and or? I presume that's what you mean by elements. They are and. All the elements are cumulative. So it is possible for one or more elements to be legally waived. For example, in Stand Your Ground states the element of avoidance, whether there's a legal duty to retreat, is typically waived. It's not required in an otherwise lawful case of self-defense. But whichever ones are not waived are required, and all the required elements are, well, they're required. They're cumulative. So the prosecution doesn't have to disprove your claim of self-defense in its entirety. They have to disprove beyond a reasonable doubt any one of the required elements of self-defense. If they can do that, then as a strictly technical matter, you don't have a claim of self-defense because you're missing a required element. Dave asks, is the 5-year platinum member special still going on? I don't think it's supposed to be, Dave. But sometimes we're bad about closing down our promotion pages. Let me take a quick look and see if it's still up. Actually, I won't be able to check that in real time. But if you want to check it out, you can point your browser to lawselfdefense.com/82cents. That would get you, if it's still up, if the staff hasn't taken it down over the weekend, and we had a pretty busy weekend. I had a client consult to do over the weekend. If we forgot to take it down, the page might still be up. This offer gets you 5 years of platinum coverage, which is normally $3,000. It also gets you every course, every book, and every form we have available, $3,000 worth of educational content, our full-day advanced course, our defense of property, defense against riot, looting, arson, how to pick self-defense insurance, a ticket to our next full-day live advanced class for you. And by the way, this coverage also applies to your spouse. If you're married, no extra charge for that. So $6,000 worth of content and benefits here in terms of platinum protection coverage. And platinum coverage is the only way you can get me available to consult on your case, to be a expert legal advisor on your case if you're involved in a use of force event. We don't take outside consults anymore. We only do them for our platinum members. You can get all this for 82 cents a day at lawofselfdefense.com/82 cents. But folks, if that offer page isn't down yet, it's going to be down pretty quick. In fact, right after the show ends, it'll be down because it's not supposed to be up anymore. So if it's still up, you're lucky. You have a grace of about an hour or so to take advantage of this. lawofselfdefense.com/elements. Let's see. Yeah, if the page is up, it'll work. So it's not supposed to be up, but if it's up, it'll work for you. Let's see. Chris asks an interesting question. It's not really pertinent to today's topic, but defense of an occupied vehicle that is open, like a convertible, or an old Jeep, or a motorcycle. How would entering a vehicle apply there? Yeah, it would be a more difficult argument to be made. Conceptually, the whole point of a defensive vehicle being treated like defense of a home is when someone's making an unlawful enforceable entry. You would argue, I suppose, the argument I would make with an open vehicle, like a car, at least a car has some kind of framework boundary, right, around the passengers and the driver. You would argue that someone's violating the plane of the enclosure, even if there's not a physical barrier. Much like someone can break and enter into your home without literally having to break something. They're breaking the plane of the home. If there's a doorway without a door in it, it's just open, and they step through, they've broken the plane of the home for purposes of breaking and entering, not typically for use of force purposes. Use of force purposes, normally they want you to, they want the bad guy to have physically broken something to get in, so that there's no ambiguity about whether or not they're there with malice in mind. So with respect to something like a convertible or an old Jeep without doors on it, someone could just, they don't have to open anything or break anything to enter the vehicle. The argument I would make is they're breaking the plane of the vehicle. And then it's up to the judge to decide whether or not they're amenable to that argument. On a motorcycle, it's much more difficult because there is no enclosure at all. So how do you enter a motorcycle? I think that would be a tough argument to make. Tony asks, in a duty to retreat state, how would the law see a third person intervene during an active shooter event? Tony, you're a member. Obviously, you're asking this in the member chat. I'm going to ask you to just ask that question again tomorrow in tomorrow's show, if you can be here, because it'll be a much shorter show. I'll have more time for questions. Today is going to be kind of lengthy because I have to read through this appellate court decision, so I don't want to get too sidetracked in other topics. Let me see if there's any super chats yet that need to be addressed. Oops. Not on YouTube. And let's see, Rumble Rants. No Rumble Rants yet. Okay, so let's get to this appellate court decision. And I'm just going to pull this up on Lexis for everybody. So Lexis is the two major professional legal databases. The ones you pay for, so the good ones, are Lexis and Westlaw. In my office, we use Lexis. It costs us literally thousands of dollars a year to have Lexis access. But of course, that's part of having a legal practice in the modern era. So I'm just going to pull this up so you can kind of see what that looks like on Lexis. So this is just the web search interface. Darby versus State. We have what's called the citation to this appellate court decision, which is like, think of it as a license plate number, the unique identifier for a particular decision. William Darby versus State of Alabama, Court of Criminal Appeals. Let's see. So Alabama is one of those odd states that has two distinct appellate court entities. They have one court of criminal appeals for criminal matters and a separate court of appeals for civil matters. A couple of states do that. Texas does something similar. Oklahoma does something similar. It's not a common structure, but in any case, here we're dealing with the Court of Criminal Appeals for Alabama, and this decision was handed down on March 24th, 2023, so just a couple months ago. And then Lexis adds in a lot of proprietary analysis stuff. I'm going to skip all that. So the decision you find on Lexis is a mix of kind of public document content, which is the opinion itself, and proprietary analysis that Lexis adds in, which frankly their analysis is often a mixed bag. Someone in the comment mentions Pacer. Pacer, P-A-C-E-R, is an online database that's very helpful for accessing court documents. That's what I usually use it for. I don't usually use it for decisions because the decisions I usually get on Lexis, but motions, various filings with the courts are often available in Pacer when they're not available on Lexis. So the judge who wrote this decision has a pretty cool name. His judge is actually McCool. No kidding. Judge McCool wrote the decision here. It's a unanimous decision. 1, 2, 3, 4, 5 judges here. They all concur. Judge McCool not only wrote the majority decision, he also wrote a standalone concurrence. So there was a couple issues here that the general members of this court didn't want to bother addressing. McCool thought he wanted to address it separately. But the part of this decision that's has precedential value, that's controlling law, is this first part, the main opinion that's signed onto by all the members of this court. So Judge McCool, writing the majority opinion, the appeal arises from an incident in which Jeffrey Parker was shot and killed by William Darby, a Huntsville, Alabama police officer who was on duty at the time of the shooting. Darby was subsequently convicted of murder and sentenced to 25 years. On April 3rd, 2018, Parker telephoned 911 and threatened to blow his head off. So officers Janisha Pegway, I don't know how to pronounce that, sorry, and Justin Beckles of the Huntsville Police Department were dispatched to Parker's residence. When they arrived, Officer Pegway drew her handgun and stepped over the threshold of the front door. While standing partially inside the residence, she saw Parker sitting on a couch with what looked like a weapon to his head. Officer Beckles was on the porch behind her and could not see Parker, but Officer Pegway told him that Parker had a gun to his head, and Officer Beckles radioed that to dispatch so that other officers who might be responding to the residence would know that there was a gun in play. So the gun matters, right? Darby was on duty at the time and was pretty close to the Parker residence, so when he heard Officer Beckles come over the radio and mention a guy with a gun threatening suicide, he began driving toward the residence to provide assistance. It would later be determined that Parker was actually holding a flare gun that had been intentionally painted black, but there is no evidence indicating any of the officers were aware of that fact. So they reasonably perceived it as a gun. They can treat it as a gun. Meanwhile, the female officer Pegwas was still standing partially inside Parker's residence, was talking with Parker in an attempt to prevent him from committing suicide. And although she had drawn her handgun, the gun was muzzled down, so she was just holding it at her side. Parker was calm. All these are references, folks, are references to transcripts. So it's important to keep in mind that the appellate courts don't hear witnesses. They don't hear testimony. They can't evaluate the demeanor or credibility of a witness. The appellate courts are looking at transcripts of testimony from the trial. So that's what they're referencing with these little parenthetical remarks. And the female officer believed the situation was de-escalating. Of course, she's inside the house looking at Parker, right? So Officer Darby's outside the house with his shotgun, or soon will be. During that time, Darby arrived on the scene, armed with a shotgun, and he approached the residence, saw the female officer's handgun was not raised, prompting him to command her to point her effing gun at the suspect, Parker, because Parker could kill her. According to the female officer, Parker heard Darby yelling from outside the residence and in response said, "I don't want to hurt anybody," or something to that effect. However, neither of the male officers heard that statement. When the female officer heard Darby command her to raise her handgun, she moved forward so that she was full body in the home and raised her handgun, but almost immediately lowered it again. At that point, Darby and the other male officer entered the residence and began demanding that Parker put his weapon down, which was still pointed at his own head. We'll have video of this at the end for the Law Self-Defense members after we cut off the YouTube and Rumble streams. and Twitter stream. The female officer testified that she could feel the tension just rising when Darby entered the residence, so she began to plead with Parker to put his weapon down. However, despite the officer's commands and pleas, it was undisputed that Parker never moved the weapon from his head, and seconds after entering the residence, Officer Darby shot and killed Parker with the shotgun while Parker was still seated on the couch. When asked if she felt threatened by Parker, the female officer testified that Parker did not threaten her or behave in a threatening manner, that he did not do anything to make her believe he wanted to do anything other than commit suicide, and that she didn't think he was an imminent threat to anyone but himself. So that's the key issue in this case, right? Whether a reasonable person in Darby's position, the person who fired the shot and is criminally charged, could have reasonably perceived an imminent threat from Parker. Darby says yes, he had a gun in his hand. He could easily have, in an instant, have started firing at us. He refused our multiple commands to put the gun down. That meant he was an imminent deadly force threat. His fellow officer, the female officer, is saying, no, Joe, I didn't feel there was any imminent threat at all. Of course, her perception is not binding on him, but it's certainly a fact that can be considered by the jury, because obviously the jury's not in the room, right? So they're relying on the testimony they hear in court from the people who were in the room. The male officer's testimony was consistent with the female officer's testimony. According to him, although Parker refused to put down his weapon, he did not show any hostility or aggression towards the officers, didn't make any overt act to indicate that he was about to point his weapon at the officers, and appeared to have the intent to harm only himself. In fact, the male officer testified that he definitely thought things were going in the direction they needed to go before Darby arrived. The male officer did testify that if Parker had continued to refuse to put his weapon down at some point, the officers were probably going to have to end up terminating that threat. So now the dispute between the male officer and Officer Darby is not really whether or not the shooting would have been appropriate, but whether Darby didn't wait long enough before shooting. Let's see. However, the male officer testified that at no time during this event did he feel the need to take deadly force action. Now, Officer Beckles testified on cross-examination. So Officer Beckles presumably was a witness for the state. So cross-examination means he's being questioned by the defense here. The appellate court doesn't tell us that, but that's a reasonable presumption. Question. This would be from defense counsel for defense for Darby. Would you say this individual holding a gun inside that house, he obviously had it in his hand regardless of where it was pointed, did he present an imminent threat to you three officers? The male officer. Yeah, anybody with a gun. Yeah. Question. Okay, does a person have to point that gun at a police officer to be an imminent threat? Male officer. No, just due to the slower reaction time we're going to have. No, they don't have to actually point it at us to be a threat to us. Question. Defense counsel. Okay. And he wouldn't have to move in any particular way to become a threat, would he? Male officer. I would prefer it, but I don't think nothing in the law that I've read says that they have to point it or make or take the first shot. Defense counsel. Okay, and what about the protocol for the Huntsville Police Department and the procedures in place for this kind of call? Does a person have to move or point their gun at an officer before an officer can take action and stop it? Male officer. No. Defense counsel. Okay. How many times did you officers, all three of you, tell this person, Parker, to put the gun down? Male officer. I think I told him 2 or 3 times. I think the female officer told him once or twice, and I think Officer Darby told him twice. Defense counsel. Okay, so about 7 times. Yes, sir. Defense counsel. Okay, and did Parker comply? Answer. No. On redirect examination, so this would be re-questioning by the state, the male officer clarified that he believed Parker posed a potential threat to the officers, but did not believe they were faced with the imminent use of deadly force that required them to use their own deadly force. So what's the difference between a potential threat and an imminent threat? Well, a good framework for evaluating imminence is something called the AOJ triad: ability, opportunity, jeopardy. When all three are present, you have an imminent threat. If any one of those, A, O, or J, is missing, you have a potential threat, but not yet an imminent threat. So ability has to do with, does someone have the ability to cause harm? Well, clearly Parker did here. He had a gun in his hand. Did he have the opportunity to bring that harm to bear against the officers? Well, it's a gun. So in an instant, he could point the gun at them and begin firing. So he had the opportunity. The question here is jeopardy. That's the key issue in this case. Jeopardy has to do, because anytime you're standing anywhere in sight of a uniformed police officer, he has ability and opportunity, right? He's got a gun. He's close enough to you to shoot you with the gun if he wants to. But he's not an imminent deadly force threat because there's no jeopardy. Jeopardy addresses the question of, is there evidence? Is there something about the person's conduct that suggests they're about to bring that ability and opportunity to bear against you? Often this is a requirement of kind of some overt physical act. So you have ability, you have opportunity. Is there jeopardy in this case? With Parker standing there holding the gun to his head, is there jeopardy? Because you need that jeopardy to have an imminent threat. Now, I'm not saying there is or isn't. This is a fact question for the jury to decide. But that is the fact question for the jury. Let's see. According to the male officer, a police officer is not authorized to use deadly force simply because a person has a gun to his own head and does not comply with a command to put the gun down. Rather, the male officer testified that pursuant to Huntsville PD's standard operating procedures, the use of deadly force must be in response to a threat of death or serious physical injury that is immediate, certain, and unequivocal. And according to the male officer, Parker's actions did not rise to that level. Detective Joshua Vogel of the Huntsville Police Department conducted the investigation of Parker's death, and as part of his investigation, he interviewed the female officer, the male officer, and Darby. It appears that Detective Vogel also viewed the audio-visual recordings taken from the officer's body cameras. Again, we'll look at those at the end of today's show for you law self-defense members. Detective Vogel testified he did not find any evidence of any kind that Parker ever did anything aggressive or ever made a hostile determination towards anybody other than himself. On cross-examination by the defense, Detective Vogel conceded that an armed subject is always a danger to a police officer. However, consistent with the male officer's testimony, he testified that pursuant to Huntsville PD policies and procedures, there is no imminent danger to the officer unless there is an action by that individual that is unquestionable. And according to Detective Vogel, Parker's refusal to put his weapon down did not rise to that level. Darby himself, the defendant, testified in his defense. So he took the witness stand and explained the reasoning behind his decision to shoot Parker. Now, they don't say here whether this was a direct or cross-examination. Let me see if I can tell from the questions real quick. It has the feel of direct. So it could be direct by the defense once the state has rested. This is when he would be called as a witness, one would expect. The state rests. It's time for the defense to present their case in chief. And one of the defense witnesses is Darby. So they're direct questioning their own client, Darby, on the stand. All right. So question, presumably by the defense. All right. Tell us what happened. Darby: I'm third man on the scene. I've got the female officer right in front of me, and I've got the male officer inside the residence where we know we have a man with a gun. So my mind is racing, and I'm trying to get as much information about the situation as possible and trying to take it in. I move closer to where I can try to pick up on what the female officer is doing. It seems like she is having some type of verbal exchange, but she's not protecting herself. How is she not protecting herself? Her body language, where she was standing, it was like she was talking to someone and had eye contact with someone to where she could see them and they could clearly see her. And we know he has a gun and we know it's in his hand because she said he had it to his head. And by the way, when you see the video, you'll see she does look rather relaxed when she's engaged with Parker. What made me think she wasn't protecting herself is, number one, it looks like you have eye contact with him. So that means he can see you. Your body language as you're talking to him. And on top of that, she's not pointing a weapon at him. She's holding her weapon in her right hand pointed at the ground, which is not what we're trained to do. And that caused a lot of fear for me. The fear that I was about to watch something very bad happen to one of my officers that I work with, as in she was going to be shot because she wasn't protecting herself and she could see a subject that we know to be armed. Did she appear to be standing in the fatal funnel? The fatal funnel, folks, sometimes referred to as the door, as the ways of death. They're constrained space environments where you don't have cover, concealment, or freedom of action. Typically, they're doorways, stairways, and hallways are the three fatal funnels. And here she was standing in the doorway. Did she appear to be standing in the fatal funnel? Yes, sir, right in the middle of it, which is the doorway. All right, what happened next? Darby: Well, I see this, so I give her a verbal command, point your gun at him, and I said it loudly, said it to be heard, and you have to raise your voice to cut through the intensity of that situation. I yelled loud enough to where she could hear me through the intensity of the situation and the radio going on, and who knows what was going through her mind. Point your gun at him. He can shoot you. And she listened to me for a second because she knew, and she raised her gun. But it was for less than a whole second, and I couldn't believe it. I saw her raise her gun, and then she put it down. And she's in the house, and she puts her hand up in front of her and says, no, he's right here in front of me. So right now, my fear is through the roof. I have an officer standing in the fatal funnel that's not protecting herself, that has admitted he's right here in front of her, and she has her hand out, and she put her gun back against herself, pointed at the ground. Is this hand signal that you saw, is there training for that? Is that part of the procedure to put your hand up? Darby, no, sir. To me, it just seemed like she was losing control of the situation. To me, it never seemed like she had control of the situation, and this was just getting worse. All right, what did you do next? What happened next? Darby, I remember saying, point your gun at him. He can shoot you. And I gave her time because I wanted to believe that her and the male officer in front of me, something would change. And I'm standing there, and I'm looking at them, and I'm processing what is happening, what's about to happen. What do I know from my training and experience? What do I actually have right here? And I wait for a second or two, and I was hoping that something would change. She stalled. She said, he's right here in front of me. She takes a big step to the left, further into the house. I'm right up behind the male officer. She takes a big step to the left, further into the house, which appeared to me as in her stalling. Her verbal communication has ended. She was ready for me and the male officer to get in that house to back her up. The male officer saw I had a shotgun and let me go in front of him. I moved into the house. The male officer comes in behind me. I'm the point man. The female officer is behind me. The male officer is behind me. We're referred to being online as everybody being even. We weren't even. I believed I was the first verbal command, and I yelled it from outside the house. I said, put your gun down, because no one else had said it that I knew of. The subject did not put his gun down. We're in the house, in clear shot of the subject with the gun in his hand with nothing in between us. You had no cover. You had no concealment. I'm point man now. I've taken the situation because I was not willing to stand outside and let what was going to happen. So I'm in the house. I'm in front. I point my gun at the individual with the gun in his hand and a finger on the trigger. This is the suspect. And I gave him a very loud and distinct verbal command to drop that gun. He said, I'm not going to drop the gun. I said, I'm not going to tell you again. Well, I'm still pointing my gun, the shotgun, at him. I said, I'm not going to tell you again. And he looked at me deadpan in the face, eye contact, and shrugged his shoulders and shook his head like he was calling a bluff. No emotion. That caused so much fear. I mean, it was all the precursors of intent. And after I said, I'm not going to tell you again, and he shrugged his shoulders and shook his head. When he shrugged his shoulders, the gun moved in an upward position. Now, it never left the vicinity of his head, but when he shrugged his shoulders and shook his head after I told him, I'm not going to tell you again, the last thing I remember seeing is him shaking his head and shrugging his shoulders, and I fired one round at the subject. Question from the defense. When you approached the stoop, what was your training telling you to do? Darby, to coach an officer into a better position to defend herself. And when that wasn't working and she didn't listen, my training was not just stand by, it's to take an action and to prevent that from happening. My training was to get that person, to remove the threat to my life or anyone else's that is a threat to. Why didn't you reach in and grab her by the arm and pull her back out the door? Darby, that was one of the things that ran through my head when I turned to the left. And as soon as I thought about that, I thought about a negligent discharge. She's obviously not thinking correctly. If I put my hand on her, that could cause a sympathetic response. She's already got her hand on her gun. I didn't want to cause her to accidentally shoot herself or shoot me, or she starts fighting with me because it's a sympathetic response to then pull away when someone grabs you. We're both hung up in the fatal funnel and no one is paying attention to the threat, the individual with the gun in his hand. So getting shot, her accidentally getting shot, or both of us getting shot by the threat that no one is paying attention to didn't seem like the best course of action. Question, why didn't you tell her, back out, back out, back out? Darby, she wasn't listening to me to keep her gun up. At that point, she wasn't listening to the coaching from outside to protect herself. I didn't see any point in wasting any more time. She, at that point, I believed, especially when she moved to the left, so we, the male officers, could go in. I had to go in. To stand there and to try to coach her anymore is just wasting time. And the time was ticking. And I thought if I waited any longer, she was going to get shot. So that was direct examination of Darby by his defense team. Now we have cross-examination by the state, as you imagine is going to be much more hostile. On cross-examination, Darby testified that Parker's refusal to put his weapon down constituted an imminent threat to the officers' lives. Again, that's the key question, right? For the jury to decide. Darby then testified as follows. So this is the state asking questions now, the prosecution. Simply holding the gun, pointing it at himself, was the imminent threat to your life? Darby: no, as I've explained before, there's no cover between myself and the other officers and Parker, and under Alabama state law, it's considered an action, the omission of an act, possession of a gun, not responding to lawful commands by an officer to drop your gun. That all goes into being an imminent threat. I'm kind of surprised, frankly, that the trial judge allowed this. Normally, witnesses are not allowed to testify as to the law. The judge is supposed to instruct the jury on the law at the end. Prosecution. So he had done something worthy of death. This is of course is inflammatory rhetoric by the prosecution. The legal question is not whether the shot suspect was worthy of death. The legal question is whether or not the shot suspect reasonably presented as an apparent, imminent, unlawful, deadly force threat to the officers. It's not a question of deserving to die. Prosecutor. So he had done something worthy of death? Answer. In the whole part of this case, he did things that required deadly force be taken against him. Prosecution. And correct me if I'm wrong here, but the choices that Parker took, the hostile action that he took that day, was he called 911, he pointed the gun at himself, and he did not put it down when you told him to. Did I miss anything? Darby. What he did to forfeit his life that day is he was in possession of a firearm in the same room with police and refused to put that gun down 7 times. And there were pre-assault indicators that I reasonably perceived through my training and experience, and he did not put down the gun. And on top of that, the last thing I saw was a deadpanned eye contact, shaking his head no, telling me he wasn't going to put the gun down. And when he shrugged his shoulders, I saw the gun started to move, and I broke the shot. That's what forfeited his life, was him. He decided not to obey one of those 7 lawful commands to remove the imminent threat to our lives. Prosecution. I'm going to go back to something because that was the first time I heard you mention it. Was what pre-assault cues? Answer, pre-assault indicators. Maybe that was it, pre-assault indicators. I want you to specifically tell us the pre-assault indicators that Parker had. Darby, extremely calm and defiant in the face of police with a gun involved, finger on the trigger to where he could readily use it, defied 7 lawful commands. A behavior of defiance, abnormal emotional state, the call details, the way he was acting in that room, thing after thing just added up to the totality of the circumstances that showed me his intent, and they add up to where I had to make the ultimate decision. And that was that's all we have from the appellate courts on the cross-examination of Officer Darby, Defendant Darby. The opinion then goes on to tell us that Darby also presented testimony from 3 other law enforcement officers who each testified that Parker's refusal to put his weapon down constituted an imminent threat to the responding officers' lives. Captain Dwayne McCarver of the Huntsville PD testified there is absolutely an imminent threat to a police officer when a person is holding a firearm and refuses to put it down after being told to do so 7 times. So according to Captain McCarver, Darby acted in compliance with his training and did exactly what he was supposed to do when he shot Parker. Ron Kiker, the assistant police chief at Snead Police Department, similarly testified that when a police officer confronts an armed person, there are a lot of physiological cues that would indicate that an attack is imminent, including the person's refusal to comply with the command to put the weapon down. Curtis Parker, a special agent with the Federal Bureau of Investigation who teaches an officer survival course, likewise testified that a police officer faces an imminent threat when a person with a gun is non-compliant with orders to drop the gun. In addition, Darby presented extensive evidence regarding the training a police officer receives with respect to confrontations with an armed person and the difficulties involved in safely navigating such confrontations. So this is the disputed evidence, right? On one side of the equation, we have, hey, the guy was just sitting on his couch, pointing the gun in his head, never threatened any of the officers explicitly, therefore was not an imminent threat against which deadly defensive force could be used. That's the argument for the state. The argument for the defense is merely having the gun in his hand, finger on the trigger with the officers in front of him, no cover, no concealment, could be shot in an instant, non-compliant with repeated verbal commands to put the gun down. That conduct itself represented an imminent deadly force threat to the officers. And in the absence of clear law distinguishing those 2 scenarios, this is going to be a fact question for the jury to decide. And the jury heard all this evidence, and the jury returned a verdict of guilty. And I can see in the comments, some of you would agree with that verdict. Some of you might disagree with the verdict. But this is where the appellate issue comes into place. And I'm not going to read the entirety of the decision for the remainder, because it's they spend a lot of words talking about really what the core issue is here for terms of reversing the conviction. I will put a link to the decision in the description for the law self-defense member. So if you're a law self-defense member, when this goes up as a blog post for all of you, with the video and audio, of course, the members only podcast, you'll have a link in the description to this decision so you can read the entire thing. But in effect, what happened at the trial court was, when it came time to instruct the jury, the defendant requested a jury instruction saying that the jury should evaluate Darby's decision-making from the perspective of a reasonable and prudent police officer who decided to use force against Parker. The judge refused to do that. The judge gave the jury instruction that would apply to any of us, non-police officers. The judge instructed the jury that the jury should evaluate Parker's use of force from the perspective of a reasonable and prudent person, period. And Darby wanted the instruction to say from a reasonable and prudent police officer. The trial judge refused to do that. The trial judge only told the jury, evaluate it from the reasonable perspective of a person, generally. And Darby got convicted. And a few months later, he got sentenced to 25 years in prison, and he appealed his conviction on the grounds that the trial judge committed reversible error when he failed to instruct a jury that they should consider Parker's use of force from the perspective of a reasonable and prudent police officer, not just a general member of the public. And the appellate court agrees with that argument. The appellate court agrees that the jury should have been instructed to consider Parker's use of force from the perspective of a police officer, not just a layperson. That's why they're reversing the conviction. Now, when they reverse the conviction, again, they're not saying Darby didn't commit a crime. They're not making a determination of guilt or not guilt. The appellate court isn't. They're saying there was a technical legal error committed at trial. Darby's whole offense was that he did this as a police officer. So the error was not harmless. The error could have made a difference in the verdict. And because the error occurred and it was not harmless and it was preserved by appeal, the conviction is reversed and remanded for a new trial. So they're not letting Darby go. They're saying Darby needs to be tried again if the prosecution wants. But when he's tried again, he gets the jury instruction he wanted in the first place, that his conduct is to be judged by the perspective of a police officer, not just a layperson. And you can see how that could make a difference, right? Because a layperson, for example, would not be permitted to enter someone else's home with a shotgun just because the person inside the home was committing suicide. That's not your job. But a police officer would be. So there's distinctions between an officer's privilege to enter a dwelling, to threaten force, to use force, and a layperson. The fundamental elements are the same, but the context in which the elements are applied differ because of the officer's legal duties and privileges as a sworn officer. So that's where we are on that, and the conviction was reversed and remanded for a new trial. Now, again, many of you, and especially when we see the video, I think reasonable people could fall on either side of this question. That certainly the other two officers involved testified under oath that they didn't feel they were facing an imminent threat of death, and that's why they weren't using deadly force against Parker. Is that controlling on Darby's perception of a threat? No. But might a jury take that into consideration and deciding they're going to lean in the direction of the two officers who didn't perceive an imminent threat, that their perception of the situation was reasonable and Darby's was too aggressive under the circumstances? Sure, I can see, much like with the Daniel Perry case, I can see a reasonable jury falling on either side of this issue. The difficulty, of course, and I think the appellate court's quite correct, is every defendant is entitled to the correct jury instructions. And if they don't have the correct jury instructions, the whole process is defective. The jury instructions are like the computer program for the jury. And if you've misprogrammed the jury, if the jury is going to apply the law incorrectly to the facts, as they believe the facts are proven or disproven, you can't have any confidence in the justice of the verdict. The programming has to be correct. The discretion of the jury is supposed to be in the finding of fact. not in the application of law. The judge is supposed to provide the jury with the correct law. And then the jury decides the facts, applies the law as instructed to the facts, and you end up with a verdict that, whether you agree with the verdict or not, is a result of a reasonable due process of law. But if the jury's given the wrong instructions, imperfect, defective instructions, you can't have any confidence in the verdict. And that's basically what the appellate court is saying here. Listen, put all this evidence in front of a new jury, properly instructed, and then we'll have confidence in the verdict. Let's see. And by the way, folks, I've seen plenty of video where a bad guy with a gun not pointing it at an officer and in an instant flicking their wrist, getting the muzzle on the officer, firing a shot in a split second, and shooting that officer fatally through the head. So it can happen that quick. Again, I'm not arguing here for or against Darby. I'm just saying reasonable people could be on any side of the question here. All right, let me take a look at the questions again. Just a reminder, tomorrow we have members only course on, where is it? Here it is. On a bad guy case of self-defense. I've told many of you that there's most cases of self-defense that go through the criminal justice system are bad guy cases of self-defense. They're very different than good guy cases of self-defense. And I had come across my desk today a pretty brutal example of a very, very bad guy case of self-defense I can use as a framework for illustrating why bad guy cases of self-defense matter to you. I mean, you're not a bad guy. If you're ever involved in a use of force event, it'll be a good guy case of self-defense, presumably. But those bad guy cases of self-defense taint everything, bias everything. So you need to be aware of how all that works as well. And the guy in the middle looks guilty. That's me. That's me in the middle. But that tomorrow's show will be for members only. So again, if you're not yet a member, I don't know why, you can be a member for 99 cents. Access to all our members only content instantly, hundreds of blog posts and videos and podcasts. And if you decide you don't like it, we'll give you a 200% refund. So, I mean, it's not a big refund, but we didn't take a lot of money from you in the first place, right? So it's a negative risk proposition, folks, to become a law self-defense member. And the standard membership, if you stay a member, it's about 30 cents a day. It's less than $10 a month. So $10 a month to get all your use of force legal questions answered by an expert for free? Well, for $10 a month, I think it's pretty reasonable, but you can try it out at lawofselfdefense.com/trial. Negative risk opportunity. All right, let me take a look at the questions. Let's see. First, from the Law Self-Defense dashboard, they always go first in getting their questions answered, and their questions are answered for free as part of being a Law Self-Defense member. Let's see. Law Self-Defense member Cheeky Mayor says, I'm always armed. As a concealed carry holder, am I always a threat? Well, whether or not you're a threat, that would need to be evaluated from the other party, right? Who's claiming you were a threat. Is there ability? Is there opportunity? Is there jeopardy? If you're carrying concealed, first of all, they don't know you have a gun. So they don't know you have ability or opportunity. So there's nothing for them to perceive as a threat. But let's pretend you are open carrying and they see your gun. Now you have ability to use deadly force. You have opportunity to bring it to bear against them if they're in proximity. Are you conducting yourself in such a way that a reasonable person would perceive you intend to do that to them, to use your gun against them? That would be jeopardy. That would qualify as an imminent deadly force threat. So what are you doing? Are you telling them you're about to shoot them? That's what the jeopardy is for. Let's see. Jay asks, question, whether Parker presented himself to be an imminent threat is ambiguous in this situation, question mark. In the Daniel Perry case, the victim didn't point the gun at Perry. Following that logic, would this also not be lawful? No, the Parker was an imminent threat. He was an imminent threat to himself, for sure. Right? He was threatening to take a life, just his own life. He wasn't just carrying a pistol like from his car to his gun safe. He was threatening to cause lethal harm. So that's a completely different context. David says, the more I listen to you, the less I'm convinced that any judge or jury ever gets anything right. Well, of course, we mostly cover mistakes, right? Because when things are done right, there's not much to talk about. Jason says, that's just a commentary. All right, let me check out Super Chats on YouTube. Glenn Trains, $10 Super Chat. Thank you very much. I can make that. There we go. I'm surprised you use state self-defense law. What's your opinion in light of the 4-pronged test of Gardner and a reasonable officer following his training? Well, that's what he wanted. He wanted the officer biased self-defense instruction. And the trial judge wouldn't give it to him, and the appellate court agrees that was error by the trial court. So that's what he wanted. I have to say, he argued at a trial in a very sloppy way. If you're a law self-defense member, you'll get the link to the decision. If you read the whole decision, you'll see, I mean, arguably, an argument could be made that this was invited error by the defense, that they didn't do an effective job of arguing for the jury instruction they wanted. They kind of left it on the table for the judge to give the incorrect jury instruction. Because there was a perfect argument to be made by the defense for the correct jury instruction, and they didn't make it. They made kind of a weak argument for the correct jury instruction. So they're lucky. They're lucky that the appellate court didn't say, yeah, there was an error, but you invited the error. You can't benefit from an error you invite. All right. Okay, folks. I think we're an hour and 17 minutes in. So I think that's a good opportunity. There's no more questions. It doesn't look like. And someone in the chat did say that the law self-defense members, don't go away. Don't go away. I'm going to play the video for you in just a minute. The video, the body cam video of the shooting. Someone in the chat did tell me that we did screw up, and this promotion is still up. But as soon as this show ends, as soon as I get off, I'm going to call my staff and have them take it down. So if you're interested in 5 years of platinum coverage, that's the only way to have me available to do a legal consult for you, for your defense, if you're ever involved in the use of force case. We don't take outside consults anymore. We only do them for our platinum members. 5 years of platinum membership is normally $3,000. Plus, with this offer, you get another $3,000 of all our courses, online, DVD, streamed, live, our multiple versions of our book, the print version, 4 copies of the print version of the book. You get the audio version, the video version, the ebook version of the book, tons and tons of content. You get all that, $6,000 worth of stuff for only 82 cents a day, folks. 82 cents a day. So if that's of interest for like a few more minutes, you can get that at lawofselfdefense.com/82 cents. If you go to that link and it doesn't work, you'll know the offer's been taken down. And that's going to happen pretty quick. So lawofselfdefense.com/82 cents for that offer. And all right. So with that out of the way, folks, thank you. Thank you for your attention. Really appreciate it. And I look forward to seeing the Law of Self-Defense members in tomorrow's show on bad guy claims of self-defense and why that should matter to all of us, us good guys as well. Until then, remember, if you carry a gun, if you own a gun, so that you're hard to kill, so your family is hard to kill, that's why I carry a gun, so my family is hard to kill, then you also owe it to your family to make sure you know the law, so you're hard to convict as well. Law of Self-Defense members, don't go away. I'm going to show you the body-worn camera footage now. But for those of you on YouTube and those of you on Twitter and those of you on Rumble, this ends the broadcast for all of you. Thanks for being here. I would strongly encourage you to become a Law of Self-Defense member so you get all this added content as well. So YouTube, talk to you later.